Doctrine of indoor management. What is its meaning? If there is an outsider who is dealing with a company, he is entitled to assume that everything has been done regularly done, okay, so far as the internal proceedings or management of the company is concerned. If there is any outsider who is dealing with a company, he is entitled to assume that the everything has been done regularly, uh, like he should not concern about the internal proceedings and management of the company, okay. He will assume that everything has been done regularly, everything is all right as far as internal proceedings and internal management of the company is concerned, okay. It is exception to the doctrine of constructive notice. We have already seen what is constructive notice in previous video, so this doctrine is an exception to the doctrine of constructive notice. This rule was laid down in Royal British Bank versus Tarquin 1856. Okay, this rule was laid down in this case. Therefore, it is also known as Rule Tarquin. This doctrine is also known as Rule Tarquin. Okay, so let's see what's the case law. Royal British Bank versus Tarquin 1856. What happened in this case? The directors of the bank issued bond to Tarquin. On sued by Tarquin, the bank turned back and said that directors had no power to issue bonds, as no resolution was passed to authorize them to issue bonds. Okay, the directors issued the bond to Tarquin, but the bank said the directors had no power because there was no resolution passed to authorize them to issue bonds. So the court held that Tarquin could sue. Okay, the Tarquin is entitled to take legal action against the bank. He was entitled to assume that a resolution has been duly passed. Okay, entitled to assume that directors had acted properly. Persons dealing with a company are bound to read registered documents and see that the proposed dealing not inconsistent with the documents, but they are not bound to inquire into the regularity of internal proceedings, that all the necessary steps have been taken or not, because such formalities are matters of internal management and an outsider is not bound to investigate them. Okay, so what the court said, that although the outsider is bound to read the registered documents like memorandum and articles, because these documents are public documents, okay, anyone can see the contents of these articles, but the outsider is not bound to see what is happening inside the company, what is about the internal proceedings of the company have been complied or not, what is happening inside the company. It is not his duty, okay. He will assume that everything has been done regularly regarding the internal proceedings and internal management of the company, okay. This principle is based on the principle of convenience of business, okay. If this principle is based on the convenience of business, suppose if to do business, everyone, if to do any contract with a company, everyone has to see all the internal proceedings of the company, like what resolutions have been passed, are the directors authorized or not. If they start doing this, then it will not be convenient to do business, okay. So to make the business convenient, this principle is allowed, okay. This principle is based on the principle of convenience of business, to make the business convenient. What are the exceptions, okay, in which you cannot get the benefit of this rule, that you don't have to look into the internal management, in what case you will not get that benefit? Like in case of forgery, when the person's purpose to do something on behalf of company which is not in its power, okay. If someone purpose to do something on behalf of company, he says that I am doing this on the behalf of company, but in actuality he was not having those powers, okay. In that case, yeah, rule will not apply. Or the person who wants this the benefit of this rule is having the knowledge of irregularity, okay. He was having the notice or knowledge of the irregularity, then also he made that contract. Like the persons claiming to have benefit of this doctrine have the knowledge or notice of the irregularity, in that case you will not get the benefit, because you already knew, then also you did act like this. The person is having suspicion of irregularity, okay. If by ordinary prudence, okay, if by ordinary prudence, ordinary look, on reasonable doubt, okay, one is bound to inquire into the matter. If someone is having any reasonable doubt, then he should he is bound to inquire into the matter. He cannot neglect it, and if he neglects to do so, then you will not get the benefit. Okay, that person will not get the benefit of this doctrine, that he is not bound to look into the matter. He is bound to look into the matter if he is having reasonable doubt. The reasonable doubt, from where he will get the doubt? If the nature of the transaction is unusual, or the magnitude is unusual, okay, it is not usual, then he should have reasonable doubt, and he is bound to inquire into the matter, that what is the reality. Next is ignorance about contents of articles and memorandum. If not gone through contents of articles and memorandum, or even if examined, not have revealed the irregularity. The person cannot say, oh, I don't know the contents of the articles and memorandum. The articles and memorandum are public documents. Anyone can see them, and they are bound to read those contents. Okay, if you have not gone through these articles, okay, then you will not get the benefit, okay, of this doctrine. Or even if you have examined them, then also you could not reveal the irregularity. The irregularity was mentioned in it, okay, that the company cannot do these acts. The acts which the company can do, they are mentioned in these documents. Okay, if you read those documents, even after that you have made that contract with the company, then you will not get the benefit. So this is doctrine of indoor management, that a person outsider, uh, he is not bound to look into the internal matters of the company. He will assume that everything has been done regularly, with regularity, regarding internal proceedings of company. If you want the PDF for revision purposes, you can get the download link from the description box or the comment box. Next topic we will see is promoter. Who are promoter, what are their duties, rights, etc. in next video.